SwayamPrabha. Digital India. Educated India.
Well, students, this is Dr. Ajay Kumar Singh, Assistant Professor, Faculty of Law, BHU. This is my 27th lecture. Today I am going to discuss protection against ex post facto laws and double jeopardy. So, in this lecture I would like to highlight ex post facto laws and double jeopardy and how these two important things are concerned with human rights. How under criminal justice system, authorities are supposed to protect the rights of the accused. Students, as you all might be knowing that there is a basic principle of criminal jurisprudence that is known as presumption of innocence. Every person is presumed innocent unless his guilt is proved before the court of law. So, because of this presumption, and you see the entire focus of the criminal justice system is based on this maxim, presumption of innocence. Every accused is presumed to be innocent unless his guilt is proved before the court of law. This is one aspect of criminal justice system. Another important feature of criminal justice system is fair trial. A trial to be fair must fulfill certain requirements which criminal justice system requires. For example, right to know the ground of arrest, right to know the allegation, right to be informed the ground of arrest, right to know the allegation initiated by the prosecution, right to be heard by competent court, right to be tried fairly. These are salient features of fair trial. Statement must be recorded in the presence of the accused. So, these are essential component of fair trial, so that accused may understand that even criminal justice system has provided all the basic requirements which he could have claimed against the criminal justice system. So, you see, unless and until the guilt is proved before the court of law, every accused is presumed to be innocent. Presumption of innocence is basic principle of criminal jurisprudence. Right to fair trial, a right against inhuman treatment, cruel punishment. Article 5 of the UDHR specifically talks about all these things. So, you need to remember two things before I start: protection against ex post facto laws, protection against double jeopardy. You all are required to understand that there are basic principles of criminal jurisprudence which criminal justice system has to ensure at the time of trial, even not at the time, or not only at the time of trial, but soon after the arrest of the accused until the completion of trial. As you all might be knowing that criminal justice system has four vital components. The first is police, second component of criminal justice system is prosecution, third component of criminal justice system is judiciary, and fourth component of criminal justice system is prison, that is also known as correctional homes. So, these are four vital organs of criminal justice system: police, prosecution, judiciary, and correctional home, that is prison. So, we will try to understand the concept of ex post facto laws, double jeopardy with respect to human rights. human rights, particularly human rights of the accused. Accused, as I said, accused has right to know the ground of arrest, he has right to know the ground of charges which prosecution has initiated against him and on what basis prosecution is going to prosecute him and court is going to convict him. So, accused has right to know the ground of arrest, he has also right to know allegation, charges instituted, initiated by the prosecution, so that he can defend effectively before the court of law. Unless and until charges are informed, unless and until ground of arrest is communicated to the accused, he would not be in position to defend himself. Right to defend himself, that is a fundamental right guaranteed by Article 22 of the Indian Constitution. So, section 50 of the CRPC, which has imposed obligation upon the police officer, upon the arresting officer to communicate the ground of arrest to the accused. On the other hand, accused has right to know the ground of arrest and right to be produced within 24 hours from the time of arrest before the nearest magistrate, that is the fundamental right of the accused guaranteed under Article 22 of the Indian Constitution. So, as per the mandate of Article 22 of the Indian Constitution, accused has right to know the ground of arrest and right to be produced before magistrate within 24 hours from the time of arrest, that is fundamental right, as I said, that is given under Article 22 of the Indian Constitution. Right to have a counsel, right to get legal assistance from the advocate, that is fundamental right guaranteed under Article 22. Legal representation, that is no case can be heard by the court without legal representation, without providing counsel advocate to the accused. So, this is also a fundamental right guaranteed under Article 22 of the Indian Constitution. So, arrested person has right to know the ground of arrest, he has right to have a counsel of his own choice, Article 22 clause 1, Article 22 clause 2 specifically talks about these two fundamental rights, right to be produced before the magistrate within 24 hours from the time of arrest, so that judiciary, so that magistrate may be aware about the charges on which, about the grounds on which arresting officer has arrested the accused, whether accused has committed, whether there is prima facie evidence against the accused on which magistrate can draw inference that accused must have committed a crime. So, this is the purpose of producing an accused within 24 hours from the time of arrest, so that judiciary may be informed about the arrest, and it will serve two purposes. The first is police officer, arresting officer will think twice to commit any atrocity or custodial violence. Police atrocity will not be committed by the police arresting officer the moment time of arrest or place of arrest is communicated to the magistrate. So, this is the paramount concern of criminal justice system, so that this protection has been duly recognized under Article 22 of the Indian Constitution. And he accused can claim that he must be produced within 24 hours from the time of arrest to the nearest magistrate, because that is his fundamental right, and if he is not produced within 24 hours from the time of arrest, the arrest would be unconstitutional, detention would be illegal. So, in the light of these constitutional safeguards, you all must remember these fundamental protections, these basic protections, and Universal Declaration of Human Rights 1948, UDHR 1948 has also provided certain safeguards for the accused. So, in these backgrounds, I would like to discuss first component, protection against ex post facto law, that is guaranteed under Article 20 clause 1, and protection against double jeopardy, that is a fundamental right. These two are fundamental right provided under Article 20 clause 1 and 20 clause 2. So, let us start protection against ex post facto law, how it is helpful to do justice with criminal cases, how these two protections, fundamental rights, are helpful in order to provide justice to the accused. So, let us start the first protection. Now, you can see on your screen, the first thing is no punishment without law. This is the basic principle which I have highlighted on this screen. No punishment without law. No person shall be punished in the absence of law. If any person who has not breached the law, he cannot be punished. So, a person can only be punished when he has breached the law. This is the motto of this sentence, no punishment without law. You just see on your screen. Second is rule of proportionality. You all might be doing that. Rule of proportionality is also basic principle of criminal jurisprudence. Article 21 of the Indian Constitution provides protection against ex post facto laws, and what is 21? You see, it prohibits greater penalty, protection available against crime, not against civil wrong. So, let us understand the spirit of Article 20 clause 1 is to prohibit the competent authority not to impose greater penalty for that act which was not an offence on the date of commission of the act. So, Article 20 clause 1, it provides protection to an accused who has committed any wrong which was not an offence on the date of commission of the act. That person cannot be punished for that act which was not an offence on the date of commission of the act. So, you need to remember that this Article 20 clause 1, it protects ex post facto laws, means even legislature. Here you all are supposed to know that which authority is supposed to make law. Obviously, state here means definition of state is given under Article 12 of the Indian Constitution. So, you see the fundamental rights are guaranteed against the state, and state is defined under Article 12 of the Indian Constitution, which contains Parliament, state legislature, Government of India, state governments. So, here ex post facto law word has been used. So, law is creation of the legislature, law is enacted by the legislature, by the parliament or state legislature. So, meaning thereby this Article 20 clause 1, it prohibits the legislature also, not only parliament but state legislature. Legislature cannot make ex post facto law, and by making ex post facto law, legislature cannot make such a law which can criminalize an act which was not an offence on the date of commission of the act. Neither act can be enacted nor penalty can be enhanced. So, by Article 20 clause 1, legislature, state is prohibited to make ex post facto law, and by making ex post facto law, neither law can be made by legislature with retrospective effect, as well as that retrospective law, ex post facto law, can enhance the penalty of the act. So, in this way, this protection Article 20 clause 1, it prohibits two types of act. One, retrospective effect of the law, and second is enhancing the penalty, is also prohibited by Article 20 clause 1. So, let us understand this concept with the help of judicial pronouncement. Judicial pronouncement will make this provision more clear, and you will get more clarity on Article 20 clause 1 once cases are discussed. So, now let us discuss two important case laws. As you may have some idea about Article 20 clause, you look on your screen. I just want to discuss one case, Kedar Kedarnath versus West Bengal. Kedarnath versus state of West Bengal. You see what happened in this case. In this case, Kedarnath, he was prosecuted for breach of law, and that act was punishable in 1947. So, he committed an act, and in 1947 that act provided that fine or imprisonment could be imposed upon the accused, but trial continued till 1949, and in 1949 state of West Bengal enhanced the fine as well as the imprisonment. So, this petitioner Kedarnath challenged the constitutionality of that act which state legislature had enacted, and state legislature had enacted such a law which was prohibited by Article 20 clause 1. So, he succeeded to establish before the court that when he did the act in 1947, that act had lesser fine or lesser imprisonment, but trial continued till 1949, and in 1949 state legislature enacted law, and by that law modified that law, and by that law fine as well as imprisonment was enhanced. So, petitioner challenged the constitutionality of that act on the basis of violation of fundamental right guaranteed under Article 20 clause 1. So, the Supreme Court found that act unconstitutional because Supreme Court held that Article 20 clause 1 strictly prohibits ex post facto law and enhancement of penalty. So, petitioner accused was allowed to take benefit of Article 20 clause 1, and Supreme Court held that it is violation of Article 20 clause 1 guaranteed by the Constitution. So, this is the first important case where Supreme Court held that state legislature enacted ex post facto law which was prohibited by Article 20 clause 1, and greater penalty was also prohibited by Article 20 clause 1. So, you need to remember this case. Another important case on this point is Ratan Lal versus state of Punjab. You just look on your screen, Ratan Lal versus state of Punjab. What happened in this case? This is very good case where Supreme Court held that where act is enacted by the legislature to reduce the punishment. So, in that case accused is entitled to take the benefit of that legislature by which punishment is minimized or penalty is minimized. So, where legislature has made such a law through which penalty is reduced, imprisonment is reduced. So, that reduction of penalty or reduction of punishment, that benefit would be given to the accused. So, here you need to understand that Article 20 clause 1 prohibits greater penalty, but if benefit, you all might be knowing that benefit of doubt is always given to the accused. If any benefit is given by the legislature, so the Article 20 clause 1 specifically provides that no ex post facto law, protection against ex post facto law, that act which was not an offence on the date of commission of the crime, that act should not be made an offence by the legislature after making the law. So, and no person shall be punished for that act which was not an offence on the date of commission of the crime. So, this protection is given under Article 20 clause 1, but if Article 20 clause 1 is silent, if punishment is reduced, if imprisonment is reduced by the legislature by making law, then that benefit would be given to the accused, and accused can get the benefit of that provision. This is one important aspect of Article 20 clause 1. Another important aspect of Article 20 clause 1 is this protection against ex post facto law is not applicable in civil cases, it is only applicable in criminal cases. So, where you need to remember this thing, this Article 20 clause 1, it prohibits the legislature for making any act to criminalize that act which was not an offence on the date of commission of the act. And second thing is that this Article 20 clause 1, it prohibits the legislature to enhance the penalty of the penalty or fine. Simply you can understand this. So, this is important aspect of ex post facto law, Article 20 clause 1. So, let us understand protection against double jeopardy. You see, this is a kind of protection guaranteed under Article 20 clause 2, and it is a fundamental right of an accused who has been prosecuted and convicted by a court cannot be prosecuted and convicted for the same offence twice. So, you see this concept double jeopardy, it gets authority from a Latin maxim, that is nemo debet vis vexari. You just can see on your screen, I have referred this Latin maxim nemo debet vis vexari. This Latin maxim literally means no one can be vexed twice for the same offence, and Article 20 clause 2 says that a person who is an accused has been prosecuted and convicted cannot be prosecuted or convicted for the same offence by the same court. It does not bar second trial. You need to remember that it does not bar second trial, whereas in USA, I have made this slide just to give complete information regarding double jeopardy. So, how you see how Article 20 clause 2 is different from US Constitution. In USA, the concept of double jeopardy is also recognized in US Constitution, but you need to remember that in US Constitution. So, US Constitution has recognized double jeopardy in a wider sense, because in USA protection against double jeopardy is not only available to an accused after the conviction, but it is also available at the time of trial. Once the trial begins and accused has already been prosecuted and convicted for an offence, and the trial for the same offence begins in any trial court. So, that accused can take a plea before trial court that he has already been convicted, prosecuted and convicted in a same matter by the same court. So, at the time of trial he can take the protection of double jeopardy, but in our legal system in India, Article 20 clause 2, it does not prohibit the trial court to try the case, that case which has that criminal case which has already been decided, and by that case accused has already been convicted. So, at the time of trial accused cannot take plea that it is violation of Article 20 clause 2, because what is exactly written under Article 20 clause 2 is that no person who is an accused of an offence shall be prosecuted and convicted for the same offence by the same court. This is actually written in Article 20 clause 2, but Article 20 clause 2 is silent, that no person shall be tried or convicted for the same offence by the same court. So, trial word is not used under Article 20 clause 2. So, that is why it is said about Article 20 clause 2 double jeopardy in our legal system and double jeopardy in US legal system. There is difference between these two. because in US Constitution trial word has been also used in double jeopardy, that a person who has already been prosecuted and convicted, that prosecution cannot be reopen and against the same person. So, trial is also, second trial is also barred in US legal system, but in our legal system second trial is not prohibited by Article 20 clause 2. You need to remember this thing. This is very important difference between double jeopardy and double jeopardy which we have adopted in our legal system. On the other hand, section 300 of the CRPC is more wider than Article 20 clause 2. So, how it is more wider? Section 300 is more wider than Article 20 clause 2. With the help of statutory provision, you just look on your screen. So, this I have used application of rule of double jeopardy in Indian context. So, how section 300 CRPC is concerned with double jeopardy? If you have any idea about section 300 CRPC, I have made an attempt to connect constitutional law and CRPC, so that you can get entire information. I have already highlighted this. It is more wider than Article 20 clause 2, because under section 300 an accused who has been acquitted or convicted can get protection. So, you need to remember that section 300 is more wider than Article 20. Article 20 clause 2 is similar to section 11 CPC, which talks about res judicata. I will discuss this in detail here. Now, let us understand that how section 300 CRPC is more wider than Article 20 clause 2. The Code of Criminal Procedure 1973 has also recognized the concept of double jeopardy under section 300. Section 300 of the Code of Criminal Procedure 1973 is more wider than Article 20 clause 2, which provides that a person who has already been prosecuted, convicted or acquitted cannot be prosecuted or convicted for the same offence who has already been acquitted by the court. So, it is very obvious that a person who has been acquitted by a court in any offence, he cannot be prosecuted and convicted for the same offence. It would be injustice when the same person is tried for the same offence by the same court. So, for that purpose section 300 CRPC makes it clear that where a person who has been acquitted or convicted, he cannot be tried for the same offence by the same court. You see, this protection is a guarantee. This protection is a constitutional guarantee in favor of the accused to whom court has not found guilty, and if he is acquitted by the court, he cannot be prosecuted and convicted for the same offence by the same court. One thing which you need to remember, that is appellate court can start, means higher court can again prosecute the same offender who has been acquitted by the subordinate court. Let us understand this. I would like to explain this with the help of illustration. Suppose a person who has been acquitted by district courts, district session court. Session court has acquitted Mr. X from the charges of murder. That person, Mr. X, cannot be retried by the same session court for the same murder, but where he has been acquitted by the session court. So, in case of acquittal, appeal is always made by the state government. So, where state makes an appeal against that acquittal order, there is no bar in the constitution, and constitution does not prohibit the state to make an appeal against that acquittal order. So, it's you need to remember that where a person who has been acquitted by the district court, session court, state is willing to make an appeal against that acquittal order. So, that appeal can be made, that appeal would be constitutional, and that appeal would not affect Article 20 clause 2 of the Indian Constitution. So, you all students must remember this thing, that this guarantee protection against double jeopardy is available to an accused only against the same court, only the court having same jurisdiction. One thing, but this protection is not available against appeal. If state is willing to make an appeal, double jeopardy will not applicable in that case. You must remember this thing. The similar concept has also been recognized in civil matter, and that is known as res judicata, section 11 CPC. So, why I am trying to connect CRPC and CPC with the constitution? Double jeopardy is provided under Article 20 clause 2, and I have also explained section 300 CRPC. Similar provision is given in civil case also. Protection is applicable in civil cases also, that is provided under section 11 of the CPC. It talks about res judicata. As you might be knowing that res means a thing, judicata means adjudicated. So, res judicata literally means a thing, a matter which has already been adjudicated by a court cannot be reopened. A matter which has already been decided by a court, that matter cannot be decided by the same court. So, the same matter cannot be decided by the same court. Again, I am highlighting this point, that there is no prohibition, there is no bar to make an appeal against that order if the case is related to civil case. If one party who has lost, who is not satisfied with the judgment of the civil court, is willing to make an appeal against that order, that judgment, then res judicata will not applicable, section 11 of the CPC will not applicable, will not prohibit him to make an appeal against that order. But the prohibition is the same matter cannot be reopened in the same court. It would be injustice where parties are allowed to reopen the same case in the same court. It would be injustice, and it will create multiplicity of suits, it will create doubt not only in the minds of litigants, but it will create some problem for the judiciary also. So, for that reason the concept of res judicata was recognized in civil matters, as well as the concept of double jeopardy recognized in criminal cases. As I have already pointed out that res judicata, double jeopardy, ex post facto laws, these are basic requirement of fair trial. As I said, accused has certain basic rights, certain fundamental rights, certain human rights which are provided not at international level, but even in all the democratic setup, all the democratic countries have guaranteed, have provided certain safeguards, certain human rights to the accused, which you all can understand that UDHR, Universal Declaration of Human Rights 1948, which talks about right to life, right to fair trial, presumption against innocence, right against inhuman treatment, Article 5, right against torture, right against illegal arrest. So, these are basic rights, these are human rights provided in UDHR. On the other hand, if we talk about Indian context, Indian constitution has specifically guaranteed three fundamental rights under Article 20. Article 20 has three clauses: Article 20 clause 1, Article 20 clause 2, Article 20 clause 3. 20 clause 1 talks about protection against ex post facto laws. Article 20 clause 2 talks about protection against double jeopardy. Article 20 clause 3 talks about protection against self incrimination. These fundamental rights are available to the accused. Accused has a right not to be tried for the same offence for which he has already been convicted. Double jeopardy, no accused shall be compelled to be a witness against himself. It would be violation of his fundamental right provided under Article 20 clause 3. So, these three important fundamental rights which our Indian constitution has adopted, has recognized that these are basic feature of fair trial. As I said, fair trial is a basic right, a human right guaranteed under Article 10 of UDHR 1948. Why I am highlighting Article 10 of UDHR 1948? Because Article 10 of UDHR, which talks about right to fair trial as a human right, every human being against whom allegation is made, charges are made, that human being has right to be tried fairly. So, when trial would be treated as considered as fair trial, it requires certain formalities, it requires certain safeguards which must be fulfilled by competent authority, before which an accused has been brought for the trial. So, for that purpose UDHR 1948 has a specific provision about fair trial. Right to fair trial is a human right according to Article 10, and when trial would be considered as a fair trial, that is provided under Article 20 of the Indian Constitution. As I said, Article 20 has three important features. So, these three important features are not sufficient unless we explain all the essential component of fair trial. For example, right to fair trial requires that right to be heard, right to know the ground of arrest, accused shall not be compelled to be a witness against himself, that is already provided under Article 20 clause 3 of the Indian Constitution. And above all, in order to ensure fair trial, where objection is raised by an accused that the court may be biased because the complainant and the judge has any relation. So, even in that case, it is the duty of the higher court to transfer that case from that bench, from that court to any other court. So, this is also provided in our legal system, in Indian legal system. Transfer of that is known as transfer of criminal case from one high court to another high court, from one district court to another district court. So, Supreme Court has power to transfer a criminal case from one high court to another high court. High court has power to transfer a criminal case from one district court to another district court. The purpose is to ensure fair trial, in order to ensure transparent justice, impartial justice, to repose confidence, to repose public confidence in justice delivery system. So, I just want to explain this double jeopardy Article 20 clause 2, and I have referred one important case laws, you just see on your screen. The case which I have chosen for this double jeopardy, that is Maqbool Hussain versus State of Bombay, AIR 1953, and second case is Zahira Sheikh versus State of Gujarat, AIR 2004 Supreme Court. That case is also known as Best Bakery case. Zahira Sheikh versus State of Gujarat, AIR 2004 Supreme Court. So, Maqbool Hussain case and Zahira Sheikh case with the help of these two judicial pronouncements, we will try to understand the concept of double jeopardy. So, what actually happened in Maqbul Hussain case, I just want to throw some light on this case, so that you can get entire information about Maqbul Hussain case. This is a leading case on double jeopardy. What happened in this case? Maqbul Hussain was arrested by the custom authorities for bringing gold. So, his gold was forfeited, and custom authorities, they forfeited his entire gold, and he was also prosecuted for committing crime for bringing gold illegally, for smuggling of gold. So, a criminal charge was also initiated against him. So, he took a plea before the court. It is a violation of fundamental right guaranteed under Article 20 Clause 2, because his gold was forfeited, confiscated. So, why authority is going to prosecute him, and it is a case of double jeopardy. No person should be punished twice for the same offence. So, when matter was brought into the notice, when he appealed this matter in Supreme Court beautifully made clear cut difference between quasi judicial function and judicial function, and application of Article 20 Clause 2. Supreme Court in this case made a clear cut difference about application of double jeopardy. What Supreme Court said in this case? Supreme Court said that confiscation of forfeiture of gold was the act of custom authority. Custom authority had confiscated, forfeited his gold. That is not judicial act. Article 20 Clause 2 is a guarantee, is a protection against judiciary, where a person who has already been prosecuted and convicted cannot be prosecuted for the same offence. So, there was not confiscation, forfeiture is not a part of prosecution. So, when his gold was forfeited, that forfeiture of his property gold was not part of the prosecution. And when authority lodged FIR against him, so this is a prosecution, and this Article 20 Clause 2 would not be applicable in this case, and he did not take the benefit of Article 20 Clause 2, because Supreme Court said that authority was not working as a judiciary. It was the forfeiture of gold was not act of prosecution. So, he will not take the benefit of Article 20 Clause 2. So, this is all about your Maqbul Hussain case. You need to remember that this protection is available only when prosecution is initiated. A person is prosecuted and convicted, then he cannot be prosecuted and convicted for the same offence. Another important case on this point is Zahira Sheikh versus State of Gujarat. So, you all might be knowing that this case is also known as best bakery case, and I have already highlighted the fact of this case, how this case is important in this head. Now, come to this double jeopardy and UDHR. I have you can see on your screen that how double jeopardy is connected with UDHR, Universal Declaration of Human Rights. Right to fair trial, as I said, it is provided under Article 10 as a human right. It would be unfair to punish a person whose act was not an offence on the date of commission. Protection against cruel punishment, Article 5. So, double jeopardy is an essential component of a fair trial. The moment an accused is brought before the competent authority, before the court, and he takes a plea before the court that he has already been prosecuted and convicted in a case, in the same case. So, competent authority should not start proceeding against him. The moment accused is succeeded in establishing the fact that he has already been prosecuted and convicted, court will pass a judgment, a court will release him giving the benefit of Article 20 Clause 2 of the Indian Constitution. So, this is one important aspect of fair trial and which is the mandate of criminal justice system and which is specifically provided under Article 10 of the Universal Declaration of Human Rights 1948. As I said, this protection is provided under Article 5, protection against illegal arrest, protection against cruel punishment, and it would be, you see, it would be a kind of cruel punishment punished to an accused twice for the same offence. So, my humble suggestion to all the students is that you can also refer this double jeopardy with Article 5 of UDHR. Article 5 UDHR protects a person from cruel punishment, it protects an accused from illegal arrest, cruel punishment, inhuman treatment. So, where an accused is brought before the court for the same offence, where he has already been acquitted or convicted, it would be a kind of cruel punishment for that accused who has already been prosecuted and acquitted by the court. So, this in the light of these safeguards, you need to remember that how these cases are related to human rights and fundamental rights in our legal setup. Now, I just want to correlate double jeopardy with estoppel. So, here see on your screen estoppel and double jeopardy. As you might be knowing that estoppel is a rule of evidence where a case is already decided by a court, that is estoppel against prosecution. It will work as a res judicata, but trial is not barred by Article 20 Clause 2. So, how estoppel can be connected with double jeopardy? You all might be aware about doctrine of estoppel. Doctrine of estoppel is no person can be allowed to approbate or reprobate a thing at the same time. No person can be allowed to accept and reject a thing at the same time. Either you have to accept in totality or you have to reject in totality. You cannot accept a thing at the same time, you can also reject the same thing. That is a concept of estoppel. Once a person has accepted his guilt, he cannot be allowed to discard his statement, because if you suppose if I have accepted my fault, then according to rule of estoppel, I shall not be allowed to reject my previous statement. So, once the statement is accepted, once the statement is made by a person, he will have to or she will have to stand on the same word. So, this is a kind of rule, and that rule in legal phraseology is known as rule of estoppel. So, this rule of estoppel, this double jeopardy is very close to estoppel, Latin word estoppel, just to stop the person not to not to accept or reject a thing at the same time. Either that thing must be accepted or must be rejected. So, this is estoppel, and estoppel is closely linked with double jeopardy. It is also like a res judicata, as I have already highlighted. So, this the entire focus on these two important principles, ex post facto law and res judicata, is that all the democratic countries have paid due respect these two fundamental principles, and India too has incorporated these two fundamental principles under Article 20 Clause 1 and 20 Clause 2 of the Indian Constitution. As I said, where Supreme Court is convinced that judgment may be affected there is a relation between judge and the victim, the complainant, and this vice versa is also true. If it might be, there might be several reasons for that. Judge is also judge may be a brother or sister or father. So, where judge who is going to decide a case of an accused, and accused has raised an objection that complainant and judge, there is a personal relationship between judge and complainant, the judgment may be, judge may be biased. So, in that case, if that objection is raised at district level, so High Court may transfer that case from one district to another district court. If that objection is raised in High Court, then Supreme Court has power to transfer that criminal case from one state to another state, as actually happened in Madhumita Shukla murder case and actually happened in Jahira Sheikh case. So, in Jahira Sheikh case, Supreme Court intervened and Supreme Court transferred that case from Gujarat to Bombay High Court. The only reason was just to repose public confidence in justice delivery system, just to pay the respect about that mandate, about that provision which is specifically provided in under section 406, 407, 405, 406, 407 of the CRPC, where Supreme Court has power to transfer a criminal case from one state to another state. For what? Just to ensure impartial justice, and which actually happened in Madhumita Shukla murder case. Matter was transferred from the state of Uttar Pradesh to Uttarakhand. How? You see, the procedure prescribed under section 405 CRPC is that either complainant or victim of crime can make application, Attorney General or complainant can make an application before the Supreme Court that this matter should be transferred from this court to another court, otherwise it would be injustice and judge may be biased. So, if Supreme Court is convinced with that application, then Supreme Court may transfer that case from one High Court to another High Court. The purpose of criminal justice system is to ensure justice in criminal matters, and it would be injustice if objection is raised by the victim of crime before the court and there is sufficient evidence that there is a relation between the adjudicating authority and the complainant, then either accused, even you see accused can also raise this matter, or victim of crime can also make this objection before the court. So, this is the purpose of fair trial, otherwise that people may lose their confidence in justice delivery system. So, I think you all have understood the things which I have highlighted. You see, I have highlighted Indian perspective on double jeopardy as well as US perspective on double jeopardy, article 20 clause 1, 20 clause 2, what is estoppel, what is res judicata. I also try to make relation between res judicata and article 20 clause 2, so that you can get entire information. Just to explain, just to elaborate all these concepts, I try to correlate CPC with CRPC, constitution with CPC and CRPC. So, in this way I have made an attempt to make it clear, to make this the concept of double jeopardy exposure more elaborative. This is all about your double jeopardy, UDHR, fair trial, and with this I would like to conclude this lecture, and I assume that you all have understood the things which I have just discussed. If you remember all these things, definitely you will get success in your coming examination. With this, I would like to conclude this lecture. Thank you all.
Hello, good morning everybody. I am Raghunandan Sengupta. So, I will just give you a very brief excitement area of finance, which is quantitative finance, and that has a huge market starting around about 10 years back, and it is exploding exponentially. So, what do we mean by quantitative finance? Quantitative finance is actually the application of different mathematical and statistical techniques in the area of financial markets, be it say for example derivative pricing, be it in the area of say for example portfolio management, be it in the area of asset liability management, be it in the area of portfolio management. We see that the application has exploded in such a way that there is a huge opportunity for people who have a quantitative background in mathematics and statistics. They can utilize those in the area of finance, but obviously with some prior knowledge of finance as a subject. Now, when we say about quantitative finance, as I said, it is an area of applied mathematics and statistics applied in financial markets. Use of different areas, if somebody is interested to know, we have stochastic calculus, we have derivative pricing, we have operation research, we have quantitative techniques like differential equations, stochastic calculus, time series, and they are heavily used in the area of quantitative finance as I mentioned. Now, we all know that in 1997 the Nobel Prize in Economics, so it is basically the Nobel Memorial Prize in Economics was given to the work of Merton and Scholz in the area of derivative pricing, and after that there has been exponential increase in the area of quantitative techniques in quantitative finance and in the area of different type of derivative pricing. With the advent, moreover with the advent of high ended and sophisticated computing data, big data has come in a very big way, where application areas starting from computing, from different type of algorithm design have been taken up in such a big way that nowadays at least we are able to understand that how high frequency data algorithm trading can be utilized using the concept of quantitative finance in the area of finance as such. But there is a flip side also, obviously when there is a huge amount of development. So, obviously due to some regulation errors or something, there has been some pitfalls, which I think is should be a bullet point for people who are really interested to take up quantitative finance, they should be aware. So, consider the financial crisis in 2008 and later on, and we are seeing different banks are failing, different financial institutions are facing a problem, countries are facing a problem like in Europe, in USA. So, what should be done? So, the main thing is that even if you know the technique is best for people who are investors, who are private players, organizations like banks, governments should use these techniques in a very somber manner, such that the application areas of quantitative finance using the techniques which we learned can be utilized in the best possible way to garner the overall the in depth knowledge a person has in trying to utilize these quantitative techniques in finance. And I am sure that people who have the background, who have the knowledge, who have the sophistication, who have the knowledge of the society can definitely use quantitative finance in a very big way in trying to make their mark in this exciting field, which you are going to see in years to come. And I am sure it will be a very exciting learning tool for all the participants who will take quantitative finance as a subject in years to come. Thank you, and I wish all the participants all the best and best of luck for the programs they will take. Thank you.